The court's next major case regarding LGBT rights was United States v. Windsor in 2013. As we saw in Romer, starting in the 1990s, some states adopted measures designed to limit the possibility that sexual orientation would be considered a protected class, in part to preclude the possibility of a right to same-sex marriage. The federal government also acted through the Defense of Marriage Act, DOMA, passed by veto-proof majorities in both houses of Congress and signed into law by President Clinton in 1996. DOMA stated that in determining the meaning of any act of Congress or of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or wife. Although DOMA did not prohibit states from recognizing same-sex marriage, it did mean that federal statutes relating to marriage or spousal benefits, including, for example, health care and inheritance tax benefits, would not apply to same-sex couples. When DOMA was enacted, no state had yet legalized same-sex marriage. Some states, including New York, however, recognized the validity of same-sex marriages authorized under foreign law. Edith Windsor and Thea, both women, had been together since 1963. They were registered as domestic partners in New York City in 1993 and were married in Canada in 2007. Spire died in 2009 and left her estate to Windsor. Because of DOMA, Windsor was denied the marital exemption for federal estate tax purposes and incurred a $363,000 estate tax liability. By the time United States v. Windsor was decided by the Supreme Court, 11 states, including New York and the District of Columbia, had authorized same-sex marriages. In a 5-4 decision, Justice Kennedy once again wrote the majority opinion. Justice Kennedy noted that states, not the federal government, traditionally regulate marriage. DOMA, he said, seeks to injure the very class New York seeks to protect and thereby violates basic due process and equal protection principles applicable to the federal government. He argued that the stated purpose of the law is discriminatory and that its effects are negative for same-sex couples and their children. In a dissent, Justice Roberts stated that Congress enacted DOMA in the interest of uniformity and stability, not a bare desire to harm. He noted that the majority's judgment is based on federalism, but that DOMA does not limit a state's ability to define marriage. In another dissent, Justice Scalia stated that the justifications for the majority opinion are rootless and shifting, and not clearly grounded either in the court's federalism, equal protection, or substantive due process jurisprudence. According to Justice Scalia, the majority never utters the dread word substantive due process, perhaps scenting the disrepute into which that doctrine has fallen, and does not argue that same-sex marriage is deeply rooted in this nation's history and tradition. A claim, he said, that would of course be quite absurd. In yet another dissent, Justice Alito stated that the Constitution simply does not speak to the issue of same-sex marriage and that the people acting through their elected officials have the right to define their view of marriage. In 2015, in the much-anticipated and hotly contested case of Obergefell v. Hodges, the court recognized a constitutional right to same-sex marriage. The case arose from consolidated challenges to laws in Michigan, Kentucky, Ohio, and Tennessee that defined marriage as a union between one man and one woman. Once again, in a 5-4 decision, Justice Kennedy wrote the majority opinion. Justice Kennedy stated that the Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allows persons within a lawful realm to define and express their identity. He noted that the annals of human history reveal the transcendent importance of marriage, but that marriage has always been subject to social change. He listed 4 basic principles concerning marriage. First, the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Second, the right to marry is fundamental because it supports a 2-person union unlike any other in its importance to the committed individuals. Third, marriage safeguards children and families. And fourth, marriage is a keystone of our social order, including for legal benefits. Under the Constitution, Justice Kennedy held, the right of same-sex couples to marry is part of the liberty promised by the 14th Amendment, and also is part of the equal protection guarantee. Rights implicit in liberty and rights secured by equal protection, Justice Kennedy argued, may rest on different precepts and are not always coextensive, yet in some instances each may be instructive as to the meaning and reach of the other. The right to marry, he said, is a fundamental right inherent in the liberty of the person, and under the Due Process and Equal Protection Clauses of the 14th Amendment, couples of the same sex may not be deprived of that right and liberty. Same-sex couples, he noted, ask for equal dignity in the eyes of the law, and the Constitution grants them that right. In a dissent, Justice Scalia complained that today's decree says that my ruler and the ruler of 320 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. This conflicts with the court's proper role, he said, because except as limited by a constitutional prohibition agreed to by the people, the states are free to adopt whatever laws they like, even those that offend the esteemed justice's reasoned judgment. Justice Roberts echoed similar themes in his dissent. This court is not a legislature, Justice Roberts said. Echoing and ironically reversing Alexander Hamilton's comment in the Federalist No. 78, Justice Roberts said, "The majority's decision is an act of will, not legal judgment." According to Justice Roberts, the majority's opinion had no basis in principle or tradition, except of the unprincipled tradition of judicial policy making that characterized discredited decisions such as Lochner. He suggested that the majority opinion opened up the possibility of other major changes to the law of marriage, such as the traditional ban on polygamy. Finally, he noted that the majority opinion did not define sexual orientation as a suspect class, and that, if viewed through traditional equal protection framework, there is a rational basis for distinguishing between same-sex and opposite-sex marriage. In a further separate dissent, Justice Thomas argued that the Constitution contains no dignity clause, and even if it did, the government would be incapable of bestowing dignity. According to Justice Thomas, human dignity has long been understood in this country to be innate. Slaves did not lose their dignity any more than they lost their humanity because the government allowed them to be enslaved. In yet another separate dissent, Justice Alito argued that the majority opinion violated the principles of federalism. Obergefell settled the question of same-sex marriage, but it did not by any means settle all constitutional questions regarding LGBT persons and the law. It remains unclear whether sexual orientation would be considered a suspect class under the Equal Protection Clause. Obergefell does not address other legal issues that may arise relating to transgendered persons or persons with other sexual identities. We'll come back to these questions when we study equal protection. Nor does Obergefell resolve any religious liberty issues that may arise when individuals or institutions with traditional views about marriage feel they cannot hire or serve an LGBT person. These issues have begun to be tested, as you may be aware, for example in the Hosanna Tabor and Masterpiece Cakes cases, which you can study if you go on to take courses in First Amendment and Law and Religion.